Yes, please. Give it. Place it in the file. Good. Thank you.
Mention some contempt matter before your lordship. Similar matter your lordship's bench has been fixed to on 2nd of December. Let these matter also come.
All right.
May I have your lordships kindly, my lord, to mention item number 53 of the daily list of your lordships. My lord, on 19th, item number 53.
Yes.
My lord, on 19th, this matter was comprehensively heard by your lordships, my lord, and your lordships were pleased to, my lord, direct the matter to appear under the heading to be mentioned, only for the purpose of submission of a list of dates.
Yes, yes.
So somehow, my lord, the matter is not appearing under the heading.
You have the list of dates.
Yes, yes, I have already prepared, my lord. If your lordships permit me, my lord, I can, my lord, ensure the presence of Mr. Saint, my lord, after the recess, immediately after the recess, and I can hand it over. I can submit it, my lord.
Today may not be all right. We'll fix it. To be mentioned tomorrow. It should have come under to be mentioned. Why it is not under? Yes.
I'm praying for leave, my lord, to file the memorandum of appeal, my lord, without certified copy, my lord.
Date of order.
Certified copy, I have.
Date of order.
List of dates is there.
Oh, beyond limitation.
Applied for the certified copy.
Then what?
The problem is this, my lord, the order was passed by the Honorable Justice Shubhendu Samanto, and my lord, the record is lying in the court, and the record is not transferred to the department.
So what are we to do in that? You take steps before the registry. When you know what is the issue, you should have taken steps. You should have asked them to get the record. Beyond limitation, what is the urgency? Sorry. No, you obtain the certified copy. Yes.
Permit to mention that the applicant retired and expired. His legal heir is not having the pension and the retirement benefit, so the matter should be heard.
Which matter? It is from the state tribunal.
It's state.
It will come. It is on the no upgradation. It is on the list. Inclusion you give. Just a minute. Yes.
নাম ছিল আমার 14 তারিখের 75 নম্বর কেসের ভাই আমার কিন্তু হিয়ারিং অর্ডার পাইনি স্যার আমার আমি 14 তারিখ আমার লিস্টে নাম ছিল 75 নম্বর 2010-এর আমার হিয়ারিং হয়ে গেছে সবকিছু আমি এখনো পুরো অর্ডারটা পাইনি স্যার
What is the case? Take his slip. We will see. Tell him we will see. I can't understand what he is saying. Yes.
My lord, the order was passed on 25th September, 25th September for final hearing, but for final hearing on November 24, the matter is not listed. My lord,
List it on the day fixed for the matter. Whatever day. No, list it on the day fixed. We have fixed the day for every matter. So list it on that day.
my lord, it is.
Yes.
Dear Lordship, kindly remembered that Calcutta Police ladies reservation. She was Lordship directed that violations of the.
It's listed today. No.
Dear Lordship,
Yes. Give it with the file. When is the matter fixed?
1st December
First. You send it with the file.
at 2 p.m.
Send it with the file.
I permitted to mention in respect of item number 36 of today's list. This is the file. And the file.
Yes,
I permitted to mention in respect of item number 36 of today's list. This matter is not a hearing matter, it is a residuary matter. It was never heard. There's an analogous similar matter where application was filed and that was heard 5 years back, and this was the order passed. There was two analogous matter. One matter has only came up before your lordship. It is not a hearing matter. There are two data application. The in this matter, what is appearing before your lordship, there is no affidavit has been also extended. Even the application is
so when it is called, we will see why are you mentioning? Yes. All right.
Item number 1.
Item number 1, my lord, I am appealing for the appellant. My lord, this is my appeal. This appeal has been filed, my lord, against rejection of my application for interim order. Writ petition is pending, my lord. The interim order application has been rejected. Let me first, my lord, brief your lordship about the facts of this case. I am an employee of Raja Ram Mohan Roy Library Foundation, my lord, an organization established by Ministry of Culture, Government of India in 1972. 2015, my lord, I have joined my service as field assistant. Till date, my lord, I am serving as field assistant. Now, for all these 10 years, my lord, more than 10 years, I am, my lord, posted out of my hometown. I have filed one writ petition before this honorable court. That was first writ petition asking my transfer, my lord, that was disposed of in the month of June. The Honorable Justice Aniruddha Rai directed my employer, my lord, to cause a hearing regarding my transfer to Kolkata. My applications have been rejected, my lord, challenging that I have filed this second writ petition. In the second writ petition, my lord, during when I was there my posting is now at Guwahati. Now, my lord, on 18th of July, my lord, I have received a death threat from some local people. The threat was given to, they came to my field officer, my immediate boss, senior in Guwahati, my lord. They came to Mr. Subroto Nath and asked him to inform me that if I stay there, my lord, I may be killed. The word they have used, my lord, that is Pura Marke city was Pakar Lena. That was the, my lord, language that they have used. The next day, my lord, I came back, I filed a my lord, leave letter to my employer. That was duly recommended by my field officer, Mr. Subroto Nath. Now, during my application, writ petition, my lord, has been admitted. Kindly see page, my lord, 23. This is the admission order. 23 of my stay petition, my lord. This is my admission order. The writ petition has been, my lord, admitted by the Honorable Justice.
Where is the writ petition?
My lord?
Where is the writ petition?
Writ petition, my lord. I'm sorry, my lord, the writ petition is not annexed.
So you want us to look into whether interim order is required without looking into the main relief?
No, my lord. I shall file the.
Bring it. the learned advocate.
Finally, grant an interim
Next
order till
case.
Wednesday, my lord.
Next case.
Item number 2,
Mr. Vikashananda Bhattacharya. And for your lordship order, I have served the copy to all the respondents. This is my evidence service. But one problem, Lord. Kindly make it short crossover because my senior is engaged in Supreme Court on virtual mode.
So it is served on everyone.
Everyone. Already return has come. in.
Affidavit of service taken on record. Not tomorrow. See, we are following a system. Every day we are saying, when the day is fixed for the matter, it will come on that day. So Wednesday.
December, my senior will not be available.
So Wednesday it will come. We'll see. At least we can record the appearance of the parties.
item number 3,
Pursuant to Lordship's direction, my lord, I have served upon the respondent number 3, 2, my lord, and served as filed affidavit of service. The lordship will be
Respondent number 2 is appearing. So after notice. Just give us 1 minute, sir. Give us 1 minute.
case of the my lord.
We are asking you to give us 1 minute, please.
Lord, that will appear.
Don't be impatient. We are here. Yes. You are for the principal accountant general. Yes. Yes. What is it?
Order which was passed, my lord, on 15th May 2025. My lord, denying the claim of the petitioner for interest or delayed payment of gratuity. But the petitioner, my lord, retired from service on 30th September 2020. My lord, thereafter, the PPO was issued in her favor, my lord, and the payment was made, my lord, on 13th December 2022, after expiry of 2 years. The learned tribunal has been pleased to pass order. They due to that period, my lord, some inconvenience was there, so that the payment was not made and interest could not be paid. My lord, the PPO was issued on Monday. Annexure B at page 32. 20th, my lord, October 20.
Yeah.
And thereafter, my lord,
Monday.
although the actual payment was made on 13th December 2020, although she returned from service on 20th September 2020.
Actually, there appears to be some delay on your part. There appears to be some delay on your part. No, therefore we are allowing you. You may use an opposition if you want. No, who was required to issue the PPO? So therefore, what has reached you on what day? Who is responsible? That has to be. No, you have to say when you have received also, because there you also perform a part of the function is done by you. Maybe in the end. So therefore, we don't know when it reached you, unless you say how it can be. What is your stand? That's why we are saying there is a gap. Therefore, we are allowing. Yes. an issue is
Item number 4.
Number 4, we have received the opposition yesterday.
you want time for reply?
Yes, Your Lordship.
The learned advocate for
Item number 5.
Please, Your Lordship, I am for the petitioner. The matter. The application responded.
Lord, this matter, the renewed order was challenged by the Public Service Commission earlier. Where, my lord, the Home PLA department, as well as, my lord, the Hills and, my lord, the
Home and Hill Affairs. Yes, Home and Hill Affairs.
Home and Hills Affairs Department, my lord, was party. And there, my lord, the state represented Learned AGP Mr. Tapan Mukherjee argued at length, and my lord, judgment was relied upon. And the matter is awaiting for judgment. So, my lord, this is the, my lord,
It's a
second
separate application made by
application.
Principal Secretary
Challenging
Government
the
West
same-
Bengal.
Yes, yes.
Yes.
They are also the government of
So this is arising out of what?
the same impute.
No.
Yes.
No, maybe, but I do not know. But this is my brief speech on behalf of the Principal Secretariat Government of West Bengal. Yeah,
No, but he's
to-
saying you are party in the other case also.
but this
So
is no
therefore, we want to know what is the position from you.
you know,
My lord, these are the order sheet of the last. My lord.
where we party to do that so much. Huh? We have some points to argue.
It's a secondary petition.
Yes.
Should have been heard together. Charlotte. Should have been heard together.
The matter for their, my lord, awaiting for their.
No, but
final-
are they parties in that case
Yes,
also?
yes.
I
This
don't
is the,
maybe respondent.
this is the copy, my lord. They are pro forma respondent.
Pro forma respondent. Then later can you hear our point? But that point was argued there. Or I do not know.
No,
Pro
all
forma
we are
respondent.
trying to ascertain is whether the two matters should be dealt with separately, or since you are parties and the common order is falling for consideration, whether it
Yes,
should be
right.
taken up
Since
together.
I pro forma respondent, my lord,
Yes.
the government made a separate application because it is the employee of the state government. Point is whether this
This is the copy of the,
petitioner.
my lord, the
All
last
right,
one.
just
Okay, point is, my lord, whether this respondent number 1 for Randeep Kumar Rai, he applied. He applied for Group A and Group B both. Group A is for one group of salary, Group B also. He applied for both. He sat in the examination for Group A and Group B also. He secured written test mark, he secured 521, which qualified him to take the interview, a personality test. So he took the personality test before in the Group A interview board, and thereafter also Group B interview board. Now, upon merit list being passed, he was found qualified and the merit list of Group A. He was given the employment in Group A, and he accepted employment and he started working in Group A as the excise officer.
As
As excise commissioner or something. Customs and excise in the government of West Bengal. Deputy Excise Commissioner, present designation. Commission, Deputy Excise Commissioner. While serving in that post, he made this application before the tribunal, saying that he wants Group B. That was his Group B. That was the whole dispute about. Retaining, he accepted the Group A, Deputy Excise Commissioner. While acting there, serving Group B, he applied to tribunal, saying I'm entitled to a Group B. This is not the first one when entitled to do so. Now, the department, upon why giving the marks, he found just entitled to 80 marks from the personality test. 80 marks. And if you add that 80 marks, then he is not qualified in the merit list of Group B. There are so many persons before him. The cutoff mark is much higher. His grievance is that his board of interview was comprising 2 persons only, whereas it should have been 4. So therefore, if there are 4 persons, should have been 4 persons, 80 marks which are given, that should be double. Apply the quotient, proportionate quotient. Even if that is done, he doesn't reach the merit list topping others. There will be 3 more above him, and even then he is not qualified. Now, the tribunal made in my humble submission 2 things very badly, that WPCS we appeared and showed the record and shown the affidavit also that in board of interview of the Group B was comprising 3 persons, not 2. And this was a misstatement he made. Tribunal thought, as to the affidavit, that the affidavit it is not denied, that there are only 2 persons in the board of interview. Totally incorrect. This is the thing I want to show to your lordship. Whether that was shown in your mind out in last time, we do not know. But this is the point. Please come to that affidavit of the board. I show first see the order of the tribunal. You come back to my lord's mind. Page 113, my lord. Order. Is the impugned order.
no, are you sure that there were parties there in that case?
I'm showing that, my lord.
I
This
didn't
is
know.
the
I didn't
petition, my
appear.
lord.
So if you are parties there, then what prevented you from saying whatever you wanted in that proceeding?
No, but respond. I do not.
Because under instruction, my lord, learned AGP, Mr. Mukherjee submitted, my lord.
He has appeared on your behalf.
Department was there on his back.
But when was the hearing?
We have heard this matter just before the holiday, the Shara holiday, and we have made it CAB.
I was not apprised of all these things.
So therefore, we are saying you please find out. We'll adjourn it for the day. We'll see what is.
Find out similar to whether lordship will be, this application can be heard by your lordship. Maybe if the same judgment from the same order of the tribunal.
No, but when you are already a party in that proceeding and you are represented.
In that matter, judgment not yet delivered.
Not delivered, that's correct.
Therefore, it can be heard. It's no question of res judicata or things
There's
like
no
that.
question. We are not in the least suggesting res judicata. We are saying when you are a party there, why another writ petition has to be filed? All you wanted to say, you could have said in those proceedings.
Yes, huh?
And you were very much present throughout
Sir,
the
I'm,
proceeding.
as per I'm instructed now, this petition was filed in April 2025. And then management, please tell him that when that was heard.
That was heard in September. We are telling just before the holidays.
It was pending, they should have been heard together.
Yes, but we were not. That's why we are saying you were parties.
AGP pointed out
Yes.
that the Home Department is going to file a separate writ petition. Your Lordship, at his request, adjourned the matter,
Yes.
but they didn't took any step whatsoever.
Saying all right.
Then, my lord, finally hearing was done.
We don't know. We don't remember.
Kindly
what-
mark, he's saying going to file. But Mr. whoever the learned advocate was, he was not instructed, he was not told that already filed. His petition already filed on behalf of the government.
We would like
Had that been told to you,
since-
Lordship, would have directed to be
since
heard
that,
together.
that order is not before us. We don't know. That record is not before us. Unless we see, we are not in a position to ascertain what was the position.
My lord,
So
he-
therefore, what we are
Humble
saying
Supreme,
is,
give us the hearing, I will
on-
not take long, that these points, if they are argued in the other matter, all right.
from
but
my
these are-
copy, my lord,
unless we see that record, it is not possible.
So, my lord,
and that
very-
was another bench. my
very-
lord.
And that was before another bench. He is correct. That was before the bench which was hearing these matters prior to the holiday. After the holidays, our composition has changed.
And my lord, this was not filed in April. As per my copy, my lord, it is filed in July.
July.
Yes.
And it matter hard in September.
No,
Matter hard in September.
On 4
Anyway, we are not on that
Vote
right
was
now.
not applied. The second,
4/7, the matter was,
I don't know.
my lord,
Anyway, but we'll come back to your
awaiting
lordship
for
with
judgment. It was
instruction.
Just take
Whether
up to date.
Is Lalmi taking the point that is in view of that earlier application, this petition is not maintainable? Is he taking the point? Let him take the point. I will deal with that. I can, if a second petition can be made,
Whether prior to that, whether we should be considering the matter since it has been heard by another bench.
that I didn't know. I'll take instruction from the what other things happen. But the fact
So for
remains,
today, we are
Fact-
adjourning it, and we'll also see what is there in the records in the meantime.
yeah, but the fact remains, when that matter was taken up by your lordship, another petition by the government was pending. And that was not brought to my lord's notice.
By the government council who was representing the government.
He was not, government council always not fully instructed. That's the problem.
Anyway, we'll see. We are
And
informed
my
that
submission, lordship,
we done.
open.
my lord, I am handing over the, my lord, the copies of the order of the.
I'll take it.
earlier-
We are keeping it on 9th if it is all right.
I'll take it. 9 December, all.
Item number 6.
It is to be
9th
done in
December
that
in the same position.
Huh?
The same position. my lord.
Both these matters.
In the same position, my lord.
Yes, yes.
Grateful, your lord.
Good. It should. Just send both files. I want to see. Send both files today. How it can be tagged that before another bench? On that day, if they say that it is to be tagged, then only. See. Now.
Petitioner was appointed as LDC, lower division clerk. Thereafter petitioner was initiated, FIR was registered against the petitioner. A criminal case is pending.
What was registered?
Criminal case was.
FIR.
FIR was raised. A similar issue was decided on earlier occasion in respect of two matters, Sudhir Chandra Nondi and Krishna Das. Rule 14 does not apply. He is entitled to full gratuity, madam. This is the issue. Can you come to the page, suspension order, page 51.
So his gratuity is withheld
Yes.
because the criminal case is pending.
Yes, ma'am. And he was
And criminal case is pending for what? Which
in
offense?
the lower court. FIR was registered under section 460. And
45 to 50.
Huh?
45 to 50 is the lower court.
FIR was registered 463, 465, 467. FIR was page 39, starting 7. Alipur.
No, where is the FIR? It is under
FIR was page 39.
30?
39, starting from page 39, 40 and 41. FIR was registered 463, 465, 467. And honorable you was moved a original application with honorable factor. That there is no need to continue the suspension order. Suspension order was revoked. He was allowed to
41.
join.
Page 41 is the
He returned from service 2016.
Why you have not annexed the FIR?
Yes, I am annexing my lord. Page 39. Page 39, 40, 41.
39, 40, 41.
Yes,
This is the FIR.
yes. First.
Your Lordship wants to know the nature of the criminal case.
Yes.
Page 41.
Page 41.
You are working as?
Last time I am working as a lower division clerk, my lord. There's ADSR Alipur in 1989 petition.
ADSR,
ADSR, one additional district sub register.
sub registrar.
Yes, LDC clerk, and he is retired from service 2016. And thereafter, he was promoted to the upper division clerk at the ADSR Sonar.
He has not annexed the FIR.
1998.
Maybe it is a copy of the charge sheet.
Para 4. Para 4.
Where is the complaint?
Yes.
Where is the
Complaint.
written complaint?
Written complaint, page 39. FIR was registered 463, 465, 468, 471, 474, 123. List of the complaint, page 41, last paragraph.
We are only required to see the last page of the complaint, according to you.
Study from page 39, man.
And 39 and 41 is complete.
41.
Have you bothered to look?
And
Again and again we are asking you and you are saying the same thing.
I'm placing the criminal case
The
record.
7A, it has come to us.
Page 48.
Where are 4 pages of the FIR? We are asking you repeatedly, you are saying the same thing.
Annexing the lower
We told you at the beginning FIR is not there, you said it is there. It is not there.
Lordship kindly grant.
Why you are suppressing?
Lordship kindly grant me leave to file the supplementary.
4 times we ask you the same thing. Every time you are saying it is there. It is not there. When we ask you, you should look at least why the court is making such a query. The FIR, the complaint
Not get any. Stand short by 60,000 or something.
Item number 7.
Nothing as ADF. So it is nothing. Start of it. We are waiting for recovery. That's why he has suppressed the FIR.
For the petitioner lodged to paid by this engage into Supreme Court. Or not.
Not today.
Item number 8.
Now for the petition being led by Mr. Vikas Ranjan Bhattacharya is appearing online.
Yes.
But this is not against order of transfer. My lord, you kindly turn to page 42, the order of transfer. That he has been transferred from the post of Deputy CMOH Purbo Bardhaman district to act until further order as Superintendent Darjeeling TB Hospital with immediate effect. Now, my lord, this Darjeeling district he has served, my lord, number of times before this. I shall place this later. But immediately after this order of transfer, he makes a representation. And his basic allegation is this is a functional demotion. I'll kindly turn to page 43. His representation. I have already completed more than 7 years of my service in Zone A, spreading over 3 districts, namely Malda, Alipurduar, and Darjeeling. They are marked as Zone A. This is also pertinent that my previous posting was at Karshiang in Darjeeling district itself. Then next paragraph, I am just not stressing now. As paragraph 3, as evident from the singular transfer order, even without a relieving officer, this is not a routine transfer, but an irregular one without considering the relevant extent transfer policy. My spouse is posted in Kolkata as headmistress, and mother ailing, but I am not putting much stress on that. But I have a specific stress upon that the person who has served the Zone A area for more than 7 years, a number of occasions, and now was discharging duties at Purvo Bardhaman. He has been transferred again, and the background story of transfer is that he was leading a doctor's movement arising out of unfortunate happened in RG Kar Hospital. Now, but this he made representation, and then kindly come to the next page, page 44. Paragraph 9 and 10. Pay and allowances of all the officers in the rank of DHS posted in the hills of Darjeeling are drawn and disbursed directly by DDO and the state of West Bengal, whereas that of officers up to the rank of ACMOH posted in the hills are drawn but disbursed by the DDO and the GTA, that is Gorkha Territorial Administration. Myself, being a bona fide officer of DHS rank, is placed under financial control of GTA, violating the extant norms and rules. It seems from the transfer order that filling the post of superintendent of an almost non-functional hospital in the remotest corner of the state is so urgent that the post of deputy CMOH of a large district like Purvo Bardhaman can be kept lying vacant. Therefore, these are the malice in law, which is quite reflected from this. Never in spite thereof, as an obedient person, I have joined my post, putting my representation, and kindly come to the order passed by the learned tribunal. But page 49, in terms of notification number such and such, the post of deputy CMH belongs to group A. The applicant was holding the post of deputy CMH Bardhaman. The same notification also indicates that the post of superintendent of general hospital located in district headquarters belonged to group B. Therefore, not I was in group B. Therefore, the transfer order was not in consonance with this notification for the reason that the applicant holding group A post was demoted to a post which comes under the group B. Mr. Bhattacharya also draws attention to the guidelines relating to not somebody else. This Bhattacharya is not mine. Draws attention to the guidelines relating to transfer issued by the department so and so, that the preference should be given to local medical officers. Same notification also emphasizes that the individual considerations while making transfer order should take into account a collocation of spouse. Dr. Goswami, the applicant's spouse, is working as an administrator of Kolkata. By such transfer to Darjeeling, the fact that spouse lives and works in Kolkata also not considered. These were, my lord, the consideration which was considered by the tribunal. Now kindly come to, my lord, the opinion of tribunal at page 50. Having heard the submissions of the learned counsel and after perusal of the documents in the application, the tribunal does not agree that the applicant's post has been downgraded by posting him as superintendent and later rectified as DDHS Darjeeling TV Hospital. Therefore, initially, before rectification, it was admitted a downgraded post. Therefore, the rectification would have arisen. The memo once is only a guideline relating to transfer policy. It cannot be accepted that such guideline is to be strictly adhered to. But if the guidelines are not strictly adhered to, then what for the guidelines are made? The responding authorities certainly rely on these guidelines, but administrative exigencies are also taken into consideration. The transfer order does not reflect any administrative exigency. The tribunal has been informed by learned counsel for the state that in the meanwhile, the applicant has already complied, yes, with the transfer, joined the new place of posting. Also remanded to of several judgments. I am not troubling my lord with these judgments, which is quite known to this court. Then the tribunal says, in this case also the applicant is agreed by his transfer, but no malafide intention has been suggested. What else could be suggested? That you have posted me in a functional demotional post. I have been working in the group A area for the last 7 years. Again, we are putting me there. These are the considerations. Another tribunal view of respect, Lord, is not really conversant with the provisions, how it is to be considered. Now, my lord will kindly take the trouble to turn to page 37, page 34. (20th August 2024). This called Administrative Health cum Administrative Service Cadre Rules 2004. Kindly Councillor B, Public Health cum Administrative Officers, Group B and Group A. Group B includes all posts of superintendent in different subdivision, all posts of assistant chief medical officer of health, all posts of superintendent of state general hospital under the municipalities and the notified area, all posts of superintendent of state general hospital and the headquarters of all districts or subdivisions having strength of 200 beds. Therefore, the functional responsibility is a huge thing in medical science. Superintendent of Gauhati TB Hospital, Deputy Superintendent of Behrampur General Hospital, Assistant Director of particular institute. And kindly come to me that Group B, Group A. Group A includes at the bottom TB Sanatorium, which is equal to Birbhum clinics, and superintendents of all district hospitals, other hospitals with strength above 200 beds. The two are separate zones, and I have been working in this 8 zone. I have made more than 7 years. You have again for transferred me there.
Did you file opposition before the tribunal?
No.
There is some Supreme Court order annexed with this brief. What is that?
That was the order passed by the Supreme Court while the doctor was agitating, arising out of Arjikar incident, and there is direction that this doctor should not be penalized in any manner. And he has been penalized in this manner. He is the face of this movement, Dr. Subodhana Goswami, has been transferred to the Darjeeling. That there is, Lordship knows well aware that there is no question of personal malafide in all cases. There is a malice in law. And this is malice in law, that you've exercised your power not for in a bona fide cause.
So let them at least file an opposition, since they did not file an opposition in the tribunal.
Let them
Yes, file an opposition
let them file,
within 2
let them
weeks.
take short time.
Within 2 weeks, you file it. Let we are allowing the.
Item number 9.
I've heard this matter several times, Lordship. This is relating to the petitioner is a constable under Calcutta Police, Lordship. He was convicted for the charge in a rape incident, and subsequent to his conviction,
He's a constable.
he was a constable, Lordship. Subsequent to his conviction, Lordship, he was dismissed from his service, and later Lordship, he had acquitted by this Honorable High Court. And then he, after his retirement, he claimed
Date of conviction?
date of conviction is Lordship 1993, 4th September 1993.
And when he has been dismissed?
13th September 1993.
Yes. And when he was acquitted?
Lordship, 21st May 2002.
His date of superannuation?
2004, Lordship.
Date?
Date. Retirement date, superannuation. Just one. Here. Expected date of retirement was 31st of January 2008.
8.
2008, Lordship.
Yes. So you were reinstated.
No, Lordship. After being acquitted, Lordship, he didn't approach his employer. Lordship, he went back to his native place, and under impression that he will not get anything, he went back to his native place. Later, Lordship, he approached the respondent authority for his retirement benefits. Now, Lordship, gratuity and provident fund has been cleared, but pension has not been denied, Lordship. Regarding challenging that, Lordship, we have approached the learned administrative tribunal. Learned tribunal decided against us, Lordship, and here we came before your Lordship. The contention was that the learned tribunal was that we have to challenge the disciplinary proceedings separately. Now, Lordship, this is well settled that disciplinary proceeding and criminal case are two separate issues, Lordship. But here, in my case, there was no separate disciplinary proceeding, Lordship.
Where is the dismissal order?
Lordship, page 27, Lordship. Kindly come for once. That's a one-line order. Constable.
On grounds of conviction?
Lordship, only on the grounds of conviction. There was no charge sheet, there was no witness, there is no evidence, there is no hearing, there is nothing. No disciplinary proceeding at all. In view of the above conviction, Constable such and such is dismissed from service with effect from this. Previously, he was put on temporary suspension. Lordship.
And what is the provision? It is under which rule? This order is under which rule?
Lordship, let me place one judgment, Lordship, of this Honorable Supreme Court.
Without fact and rule, go to the judgment.
No, Lordship, on last occasion, Lordship asked for the rules, and my learned friend also provided something, but that was not helpful to your Lordship. So, Lordship asked both of us to provide something better. I mean, maybe any judgment or maybe something, because rule is not specifically clear regarding this, that if there is no disciplinary proceeding, what will the
No, it is a this order is passed under which rule? There is a separate rule for the police force, or it is under the West Bengal?
State service rules.
So therefore, we have to see that.
Lordship.
The civil service rules applies to the police force also.
Calcutta Police Force.
Police regulation will not apply.
Lordship, regarding service related issues, Lordship, this will apply. This service rule will apply.
Have you examined the West Bengal police regulation?
Pension and retirement benefits.
Dismissal order is passed under which rule?
Thing is mentioned, Lord. My instructions are, my Lord.
Must be how the civil service rules will apply to the police force.
Regarding,
That's what we have been asking you from the last day.
Lordship, death and I mean retirement benefit rules, DRB rules of West Bengal service rules applies to the Calcutta police also.
So
Lord.
therefore, the service conduct rules will also apply.
Lordship, I'm
The civil service rules will apply to uniform force.
Lordship regarding pension, Lordship, I'm stating.
Where's the question of pension? The issue is what is to be done regarding your dismissal. If the dismissal is based on a conviction, once the conviction goes, are you entitled to automatic reinstatement, or they are required to examine whether they will proceed against you in a proceeding or pass an order saying that we accept and will reinstate you? So where is this procedure? We have been asking you from the last day. You are unable to.
Occasion, my learned friend placed Lordship rules before your Lordship also, Lordship.
Which rule?
They,
Show us.
they couldn't show the specific provision, Lordship.
Captain 19 Miller.
Calcutta police regulations. Is there in this somewhere?
Melody, it is in the book also, Melody.
In which book? Service rule. Give him. Give him. Give it to him. Give it.
Put it down. Yes, in the PRC collector.
Normally, the service rule retains the discretion of the appointing authority to take a decision once the criminal proceeding is over. Because finding of the criminal court need not be binding on the disciplinary proceeding. Merely because the charge could not be sustained on the strict rule of evidence does not mean that it cannot be established on the preponderance of.
Proceeding at all, Lordship. There is no proceeding at all.
Then why you were under suspension?
Lordship, they has just adopted the order of the learned trial court, and Lordship suspended me, Lordship. There was no charge sheet, there is no hearing, there is no evidence, there is nothing.
May I, Millard, place these facts according to my Millard understanding, Millard, just for a bit, little recapitulation of your Lordship.
Just a minute, you are relying on which regulation?
Then I am relying on Millard. Calcutta 1968.
Oh, regulation 5.
Millard, it's rule 5 first, then rule 4 under chapter 19, which deals with punishment and Millard. Punishment.
5 is retention in service.
It has fallen from your lordships that under which provision the dismissal order was Millard passed. Now, Millard, rule 5 under chapter 19 of the PRC states.
So that is the rule under which he has been dismissed.
Millard. Now the next question as to what is the effect of Millard acquittal in the instant case. Now, Millard, for that, Millard, I would strongly rely upon Millard rule 4. Rule 4, Millard, deals with discharge on acquittal, not a bar to disciplinary to departmental punishment. Now, Millard, the moment the petitioner was acquitted, he, Millard, ought to have joined Millard. I'm sorry, Millard, he ought to have Millard challenged the disciplinary punishment order, Millard, which in the instant case, Millard, he did not.
Yes. So 5, the order is passed under 5. And after acquittal, 4 applies according to you. And you never came back to them.
He never came back. 2008 Millard, may I say Millard? 1992 Millard was the Millard year where he was convicted.
Yes, 4993.
Millard. Now Millard is expected date of death was Millard 2008. And then he was acquitted Millard sometimes in the year 2002.
Yes.
I mean, after 2002, it says date is 21 May 2002. And then from the 22nd day of May, he ought to have approached the Millard authority or Millard the department for reinstatement. He ought to have taken steps Millard for setting aside Millard of his dismissal order. Now Millard 2008 was the expected date of retirement, and the first representation Millard claiming pension benefit and other benefits Millard was on 7th of February 2021. After Millard lapse of Millard.
And when did he get his GPF and gratuity dues?
Each salary was paid to him on 5th of September 2022. Thereafter, group insurance was paid to him on the same day, and GPF on 7th of September 2023. Participant the representation. Representation.
Which representation he has filed on 7/2/21?
21.
Where is that representation?
That is Millard.
Yes, statement. Next, anything without it's incomplete. What did you request by the representation?
Lordship, my retirement benefits.
Please show what you have requested in your representation.
I'm extremely sorry. Lordship, allow me to file a supplementary affidavit, Lordship.
How can we consider? Just see.
Lordship, that was a mistake.
Any order was passed on this representation or just dues were paid?
Order was passed, Lordship. That is why we preferred an application.
Only the dues were paid.
No, Lordship. It's not that. Lordship, since our representation has not been considered, we moved to State Administrative Tribunal. Their Lordship, while pendency of the proceeding, Lordship, they cleared this.
Yes, that's what I'm submitting.
Leave salary, GI and GPF.
Lord. So, Lordship, delay cannot be that ground, Lordship. They have already paid whatever my legitimate dues are, Lordship.
That was his Millard, the corpus was his. We have no authority
The court is not completely powerless to quash a disciplinary proceeding, Lordship, if we at all consider this as a disciplinary proceeding.
And you served how long prior to your suspension? How long you have served?
Lordship, nearly 25 years, Lordship.
In 1992, Millard was the date of incident, the year of incident. So Millard, he served between 68 to 1992.
24 years, Lordship, almost.
What was the allegation in the criminal case?
Allegation of 376. Sections are Millard, 366, 376, 114, 354 of the Indian Penal Code.
Two of them were acquitted, including my client, Lordship.
Why you were sleeping for over your rights? That is the only issue.
Lordship, that was he was under impression, Lordship. That's what he has told me. Lordship.
We don't know. We are not able to say what you have said in the representation.
These retirement benefits, Lordship, we have asked for. Already been put.
You have a copy of his
No, no,
representation.
same as Millard.
Lordship,
Only
yes.
the first page of the representation is Millard.
That is not an Lordship.
You also don't have.
Lordship, here no, Lordship.
So how will you place it on record?
Lordship, let me file supplementary affidavit, Lordship, by tomorrow, Lordship.
Yes. The issue arising for
Item number 10.
Submitted.
May it please your lordships. For my learned esteemed senior friend Stars, I seek my lord's kind leave to file a supplementary affidavit with an apologetic mind
For the respondent.
private respondent. Initially, my lord's pleasure was to request the parties in the proceeding to explore the possibility of domestic deliberation, my lord, between the parties. We tried, my lord, it is a very long-standing, passionate dispute between the daughter and her biological mother, my lord, on account of some, my lord, antecedent or the histories, my lord. We are not going into that. Parties, my lord, I am instructed to submit, subject to what my learned esteemed senior friend will say, my lord, that they tried, but ultimately, my lord, it failed. But today, my lord, I am with a supplementary affidavit seeking my lord's kind leave. The second copy, honorable judge's copy, my lord, the bond paper, my lord, it has been displayed from the custody of the honorable, the learned advocate, my lord, and I will get it done by today, my lord, by tomorrow, pardon, by tomorrow, if your lordship permits. But I will not interrupt the proceeding, my lord, on this court, subject to the leave of this honorable court, and I will submit, my lord, the bond paper for the honorable second judge I am armed with. This has been misplaced from my learned senior, my lord. But question is, my lord, if nothing was there before the learned tribunal, whether yes, they my can lord, improve he's by- absolutely right, my lord. I am in line with his argument and thinking process. It was on the part of original record. It has been misplaced or by omission, my
What
lord.
do you want to bring on record?
Bring on record, my lord, the BDO's certificate, my lord, which says that, my lord, the mother is not dependent on anyone.
So how we are to examine that issue?
Because this was a part of the way application, it has been missed. While filing this WP,
You are the writ petitioner. It was part of the OA.
Lord, so far as I understand, Lord, we had annexed the entire way because it was their way. Only one page, my lord, maybe it by omission, but it
You
requires.
check. If it is beyond the record, we may not accept. We may or we may not. You check. So the issue still remains. You are the daughter or mother?
I'm daughter. I my lord,
You are the nominee.
no, my lord, I am the plan.
Daughters, elder daughter and younger daughter. Younger daughter stays separately for the last 15 years. That was
the case. And the elder daughter stays with the mother.
mother.
So he has nominated the mother and the elder daughter.
No.
Then
Compassionate appointment.
Oh.
The court, the
Subject
tribunal,
is only NOC. Whether the short question.
So she is coming in the way of grant of compassionate appointment. She is
Mother.
not.
Mother will not give no objection because of the reason that it will not help the family at all. And my lord, the only short question, subject to what falls from my lord, is whether the learned tribunal could say that NOC is not required, although it is statutorily required under the rules. Only short question is this, subject to.
it is possibly, my lord.
How can it be without NOC?
And I have brought judgments to that.
I have some arguments to make, my lord, if your lordships, my lord, if he complete my learned senior
No,
friend.
what we have understood, subject to what you will say, that the tribunal has held that NOC was not required, so they may proceed with her claim. You are challenging that order. You say how the tribunal can direct this.
So yet, for that, my lord, one has to look into the entire order and, my lord, their perspective. Why the tribunal, what weight with the tribunal.
Whatever weight, whether such a requirement can be exempted by the tribunal or not.
My lord, the reasons must be assigned and, my lord, reasons must be placed before it in a fragmented manner, my lord, because this is a point which attracts, my lord, the attention of the court. But in order to, my lord, understand the other points of view, my lord, because the court was in tribunal was entrusted to adjudicate the dispute. It must reach the logical end. Number one. Number two, in order to arrive at a logical end, the court has, my lord, adjudicated, the tribunal has adjudicated the entire perspective. On what score, my lord? In law, is everything is in reference to context. What was that context? Why the court tribunal has? Let us, my lord, place the order. My learned senior friend is here, my lord. I am not interrupting him, my lord, and let him, my lord, place the order first under appeal.
Yes, let us see.
Gotcha. And, my lord, the affidavit, the supplementary.
Yes, supplementary affidavit taken on record,
Copy দিয়েছি।
subject to an applying the bond, the
কেন হয়তো কম্পিউটার নেই তোমার কাছে? আর কপি কোথায় তোমার কাছে?
But the impugned order is at volume 2. The last annexion, order number 11 dated 7/8/2025.
Yes.
Now, my lord, here if your lordship looks at the order, my lord,
So whatever is recorded on facts, is there any dispute?
only one.
She is living with
there.
the second wife. The elder daughter is living with
Yes.
you. Elder daughter is married. She has agreed that she will take care, and to that effect, she has given an undertaking. Now the only issue is whether NOC is to be given or not. These are the facts, or there is any dispute on this?
One mistake the learned tribunal did was, my lord, that is page. Page এখানে order number নেই, page number নেই, কয়টাই দেই দাও। ঠিক আছে, বলো ছেড়ে দাও। 23:12. My lord, if your lordship comes to the inner page 4.
Yes.
The last paragraph. The impugned order has solely relied upon the recommendation of the three-man inquiry committee. The document dated 6/1/2016 shows that Srimati Shantirani had earlier proposed the name of the applicant for the job. The impugned reasoned order also mentions that Srimati Shantirani Das had affirmed an affidavit before the judicial magistrate on 23/10/2017. This is wrong.
So both is wrong, or just the subsequent fact is wrong regarding your affidavit? So you did not affirm any such affidavit? No, we didn't ask you about this. All we wanted to know is that the family setup which has been recorded in the tribunal's order, there is no dispute on that. And the elder sister is already married.
Elder sister is married, the mother is staying with the elder sister, and there was a case before the learned tribunal that the elder sister be given appointment. That has been dismissed. That is also forming part of the order.
Yes, that has been rejected.
So we have that.
There is an order rejecting her case.
Yes, by the tribunal.
It is a common order, or it is a separate order?
Not touched.
Individual claim of the elder sister, my lord, that has been rejected by a judicial order, I am told. But this is not a part of record.
No, we have asked for prayer. We had prayed. Our prayer is there here.
In the OA?
In the separate application we had filed in the OA.
How can
because it is their OA. We had filed another.
No, when your claim was rejected, you did not approach the tribunal.
No. The tribunal rejected our order. We had paid for an application. Lord, that part is clarified. The last page of the order, my lord. There is a second certified copy. Lordship will look at that after the end of the order.
Page 6.
It would be, my lord, the last annexure. Lord, we had preferred an application there before the learned tribunal, which is MA 69 of 2025.
Yes.
That was, Lord, for appointment of the married daughter as in the died in harness category. There, my lord, the matter is taken up by the single bench pursuant to the order to the notification. Since the original application is disposed of, no order is required to be passed. So our case was not considered. Therefore, we here, my lord, in the writ petition, we have challenged this order also, and we have prayed for appointment.
And where is the MA? What was the prayer in the MA? Let us see.
MA. Page 199. The prayer is at, my lord, page 207 or 208. I'm sorry. About the rule which lays down the procedure, my lord. Copy has been annexed, but it is a little illegible. Therefore, my lord, I'm handing over a better copy.
Which one?
The rule under which the compassionate appointment is.
This is what? Which EMP?
251.
We have it. You need not give.
Because in this copy, it's not.
No, we have a compilation of all the.
Lord, Lordship looks at, Lord.
251 is of 3/12/13.
Yes.
It is of 3/12/13.
Yes. My lord, procedure. Para 10. Rule 10. Rule 10B. Application is to be submitted and my lord, 11 undertaking. person appointed on dispassionate ground under his scheme must give an undertaking initially. The learned tribunal has held so also, and then deviated. That I'll show your lordship from the order.
No, but she has given an undertaking.
No. No.
That is
The wife
required.
has not given the undertaking.
No,
I'm
wife
sorry,
will-
I'm not undertaking. Yes.
She has given an.
Yes, yes. Now, NOC, we have to give the NOC, which is the first precondition. And lordship will look at page.
NOC is required under which provision? That is a pro forma. Extra one.
Serial number 4. Signature LTA of the other dependents given the NOC in favor of this application.
Which this is annexure 1.
Annexure A. Annexure A, part 1.
Anyway, yes. All right. 143, page 143.
Now, my lord, if your lordship comes to the order, comes back to the order, my lord. Enter. Taken each.
So otherwise, if there was no dispute amongst all of you, could she have claimed, your elder daughter have claimed the appointment?
Yes.
Under which provision?
The special bench judgment is there of this.
So this provision, this 2013 provision, it has been interpreted.
It has been considered there.
And which provision has been interpreted by the special bench?
Show that.
Because you see, we are asking.
Another subject to correction. My learned senior friend, my learned advocate on record, has taken an instruction from the erstwhile advocate that there was a previous claim, my lord, set up by the daughter and mother, a married daughter and mother, which was rejected, my lord, on the ground of marriage. And such order was not questioned. I request my learned esteemed senior friend to take such instruction, since the advocate on record is not armed with the copy of such order.
No, therefore we are asking you have a look at 251 EMP.
Yes, the definition part, the married daughter on the date of the
Correct. 3D.
Yes.
Now 3D.
If that condition is not satisfied.
If that is not satisfied, then she will not be eligible anyway. We don't. Both are arguing.
They are the supporting mirror in not a discordant node mirror.
You are separately representing the daughter.
Yes, set up by one another.
Yes.
No, this unity mirror in diversity mirror is always welcome.
Let's benefit someone.
At the end of the day, simple economics.
Yes.
Now, the short question is, my lord, whether the learned tribunal could have passed that order. I'm showing that portion.
No, we have understood your legal submission is whether it was within the tribunal's jurisdiction to exempt a requirement under the scheme. That, but then what is the prejudice? That is another issue. Why you are challenging the order to that extent? If at all she is not eligible in terms of the advertisement, then we will set aside the tribunal's order for what purpose?
Because she is getting appointment.
So it will at best be between you and the younger daughter. So which one of you is eligible? Are you eligible?
The elder daughter, you are representing the elder daughter.
Yes.
By virtue of that, the special bench judgment, the elder daughter gets.
I have not seen, therefore I am not, we don't know what is the date of that judgment, whether this 3D has been read down or interpreted or what has been done.
It is there in this thing.
Or whether after that judgment this has been incorporated that a married daughter,
It is subsequent.
it is subsequent to this.
That is reflected at page 59.
The father had told the marriage took place and she was married on the day because 2005.
That fact may not be material if the special bench has said that this is the,
Special bench has considered whether the rule 3D.
that's what we are asking.
Kindly ask him to produce the judgment. So matter ends, all dispute will be set at rest.
Because if she has an actionable claim, the elder sister,
Also, my lord, even if any actionable claim, my lord, is existing on the day, my lord, even then, my lord, the previous litigation, whether it has any record, and if that claim has been rejected, kindly ask my learned senior, my lord, to take instruction.
but you have not said anything about her having moved the court earlier.
No, because my lord, my accident record has called the aspirant advocate record. The person concerned was on the way the court.
So we will record his submission in today's order.
And that judgment, my lord, is 2017 4 CHN.
Because my lord, if your lordship gives time, today's time, then you will take the instruction. Because Gitarani.
Because if specifically her claim has already been rejected, then where is the question of taking up the issue again?
That is why I am not sure about that. That is why I request my learned senior friend to take instruction.
I'll have to take instructions from.
Because he has
I
taken
was
an
not
instruction.
It is better to know whether there is any such background or there is no such background.
Because we
And
are
we'll
all.
come back with the judgment also, my lord, that judgment,
Yes, yes.
which will set at rest that aspect.
May I take my lords kindly?
Two issues. Page 362. Can you give it on a piece of paper? Yes.
And it also went up to Supreme Court. It has been affirmed. This is not legible. It is recorded in the order passed by the Principal Secretary. Yes, হয়ে গেছে।
Our scheme that is 2016. There is a compilation of
26.
2016. That is 2016.
26 EMP.
Okay. Principal Secretary order লেখা আছে his daughter qualification has been withdrawn. Daughter married at
There is no distinction now.
Actually, she went up to Supreme Court also. It has been appointed.
Yes.
Her married daughter is entitled to.
Item number 11.
এই এটাকে না গুছিয়ে আনা আমার in place of 8, you are also kindly not 11.
Not possible on 11th. Then it will come on 15.
It is,
Yes,
HON'BLE has got
15.
এইটা ফাইলে ট্যাগ করে রাখেন।
11. Yes.
Item 11.
My lord, Advocate Bikash Ranjan Yogi is appearing for the petitioner, my lord. I was to pray for not today, my lord. My lord, Advocate Bikash Ranjan Yogi is appearing for the petitioner. My lord, I'm praying for not today, my lord.
Not today.
Since according to them, they must have served the copy to the learned GP office. Now, my lord, after the the erstwhile GP, he was in this matter, and I was no brief is with me. Now, my lord, lordship kindly attend this matter for the week.
For a week.
Next week, my lord, I think if they serve us better, otherwise, my lord.
An adjournment is sought. There is in the earlier order, Mr. Sen, it is recorded. In the earlier order, it is recorded that the learned advocate general is to appear in the matter. So you please go through it. Yes.
Item 12. Item 13.
2 PM.
What happened in 12? Yes.
My lord, 8 data and data entry operator was giving a contextual appointment in the food and supply department. In latter stage, there was a screening test which was found irregular, and the matter was lodged with the SAT, and SAT and given the order to form a division bench, and the division bench will take up the matters. It is very much evident there was some irregularity in the screening, and the mark sheet is also inclusive in the annexer, but you'll find whether the total marks is 50 or they were above it 58, someone 62.
Which order is under
Annex 61.
Page 61.
Page 61.
So it is still pending before the tribunal.
For want of bench.
Constitute the bench comprising both judicial and administrative members as per their order dated to its earliest or the matter be heard by any bench as may be directed.
I think there is no point of objection. There is no more point of objection from respondent side also.
Have all paid expeditious
Yeah.
hearing that I could make out.
Actually, they are getting deprived 8 candidates.
No, the prayer is at page 36.
No, 14, your lordship.
14.
14 of the writ of the mat. 14. Mat 9, yes, W2.
WP. Oh. So then this prayer cannot be considered.
Benching.
We put your English pray. That is the point. I can show you. Yes.
That is your only prayer.
Only prayer for the
So,
bench should be there to at least not to this my client to others also.
huh?
Others also getting deprived for getting the justice from the SAT.
That is
Such an order is to be passed by the writ court for constituting a division bench, or it is for the chairman or of the tribunal to do it.
Chairman.
Then what remains? You are still working.
No, they have been terminated.
When?
In 2020. Interim order was there, but it was not honored.
There was an interim order by the tribunal.
Here on by the SAT.
What is the date?
(27/5/2020). Pastor.
What is the date?
27/5/2020. Page 55 and the number is 58.
continuing.
Continuing 58.
Then why are you here? Your interest is protected. How does it affect you if the tribunal is taking time to dispose of the matter?
They have been dropped.
Huh?
The coroner and they have been dropped.
They have
been dropped from the employment. They have been dropped from their job.
in violation of the interim order. Then you took out a contempt.
Yes.
What happened in the contempt?
Contempt was not filed, but the bench has directly told for the constitutional bench of comprehensive judicial administration to take up the matter.
When you were disengaged, when you were dropped?
The time of Corona 2020.
Sir, this order is of 2020. In May 2020, the tribunal said that you will not be disturbed.
Not be disturbed, and 30th September they have been dropped. 30th September 2020. 30th September of 2020.
They have been disturbed.
They have been disturbed.
So what steps you took?
I even approached to the SAT
for
the continuation of interim order and for the reinstatement, but the SAT has gone through the screening test.
No, we are not clear. You are saying that
and asked the status report, but status report was completely vague. They put the status report, it was not at par.
We asked.
It was filed, but it's not the status, it is a chronological chart.
How you will assist us if you don't know the facts? We are asking you, when the tribunal has passed an interim order in your favor, you say in violation of the interim order you were removed. So therefore, what steps you took, we are asking you. If the interim order was violated, why did you need an extension of interim order?
matter has been brought to the SAT and SAT has given that there should be given a status report. The status report which has been placed is totally.
It was brought before this SAT in what provision, in which provision, under contempt or under by what means it was raised before the tribunal?
Not on contempt.
Then what is the other remedy to you? If there is a violation of the tribunal's order, what remedy you have apart from contempt?
The single bench simply push it to the bench, joint.
Apparently, you are not clear with the facts. Therefore, how can you assist us? We are asking you to explain the circumstances under which you have been disengaged, what steps you have taken. You are saying two different things which cannot reconcile. You are saying there was an interim order and we have been disengaged, and you are saying we have moved the tribunal for an extension of the interim order. Where is the question of extension? If there is already an interim order, it has not been vacated. Was the interim order vacated?
Interim order not vacated, Your Honor. Not vacated. It was not vacated.
Not vacated.
Interim order was.
Kindly state it.
30th September.
Or until further order. And the extension method.
Till 30th September or until further orders, whichever is earlier. So after that, it was not extended.
I can see another order on 28.
No, it has been extended till December 2020. No, nobody is clear. Then it has been extended to March 21. How you are saying it was not extended? Then till June 21.
And then 2022. 2022.
Right one was certified for.
What it? Have a look at an order of 24/3/21. So extension till 30th June 21. Now the next order which you have annexed is of August 22. So the order lapse in between. In August 22 order, there is no extension. And there is a gap of more than 1 year. So if there is a lapse of the order and you have taken no steps, then what this court is to do? So what happened in between? 30th June 2021, the interim order lapsed. The next order is of August 22. On August 22, there is no prayer or no extension of the interim order. Apparently, you have taken no steps. If you
Stat has been approached and stat has asked the status for the state government.
What a status they have to give when there is no interim order, then what status? What prevents them from terminating you or removing you?
We ask the status report to the status quo of the candidate, what the future of the candidates, or 8 candidates. So
If
that-
you
that is
don't care for your future, what anyone will do? You get an interim order, it is vacated, you take no steps. So what is anyone to do? You have to care for your future. Who will care for your future?
we applied for the SAT, but it was the motion to just settle it, but to the ask the status report and further.
The interim order is vacated. There is no interim order. After at least after August 22, there is no interim order.
That is the plain sheet.
If we record what has been vacated before, in between this one important one, he has voted that between March 21 to August 22. There is no order. See, this day also, it was a single judge. The single judge has extended. The next day, there is no extension. What have you said in your OA regarding the interim order? When it was vacated? In before this writ court, what have you said in the writ petition? Nothing. Hmm. After that, there must have been many dates. Yes.
28.
You have not said anything. In your writ petition also, you have not said anything. No clarity or anything of any fact, and you just want that the High Court should give a direction. Very peculiar state of affairs.
My lord.
Sit down. Please sit down.
One team can.
You have got your breath.
My lord, we are making a very innocuous prayer, my lord. We are a code of Article 226. My lord is having a superintendent's power also in this jurisdiction, my lord, for constitution of a bench, my lord. Because this tribunal, my lord, would kindly appreciate, my learned friend will also appreciate this, is functioning without a judicial member for almost a year, more than a year, for 3-4 years rather, at a stretch.
We have considered the order sheets which have been annexed. Now, the way you have conducted the proceedings in the tribunal, does it lie in your mouth to say that there is any expediency? There is an interim order which lapsed in 30th June 21. After that, there are so many orders, no steps for getting it reinstated or extended or anywhere reimposed. So let it go on.
My lord,
What is there to be done?
what I have been
You have been removed because the interim order lapsed. So where is the
what I have been
urgency?
instructed, my lord, what I
Where
have
is the urgency requiring us to go into such an order or pass such an order which we normally do not do? It is for the tribunal to see its business, how it is to be conducted. In case of extreme urgency, you may be right in making such a prayer. Very rarely. Not here. You see the order of 24/3/21. Then you make any submission. This is till 30th June. Interim order. Thereafter, no interim order. Come to the next order. And thereafter, no extension, no reimposition, nothing, no steps taken by you.
What I have been given to understand, my lord, subject to correction, my lord, subject to correction. My lord, since after this, my lord, there was no bench of judicial member.
Even on that day, there was only a single member. On that day also, the extension was by a single member. So there is no incapacitation in the bench to extend the order.
But thereafter, what I have been told, my lord, maybe subject.
We are seeing your conduct, sir. Whether at the instance of such a petitioner, we are to pass such a direction. Who takes no steps before the tribunal, and he is before us that you direct the tribunal to expedite.
The only problem, my lord, a question of law is involved. So that
That
they
is
are
the
not-
question. Every question of law is to be answered with reference to the facts, attending facts. The facts here are that you have done nothing.
There is record, my lord, I will not say anything.
So there,
I will not say anything.
what we are saying is, should we record such a finding that there is no extension of the interim order after 24/3/21? We can do it. Or you want to pursue the matter. That is why we have been waiting for you.
May I make a
Yes.
suggestion subject to sanction, my lord? Let this matter be heard by my lords.
Sorry, sir. No.
Because there is no bench. Practically,
Sorry.
there is no bench.
We have asked you a specific query.
My lord, my
So
lord
that-
may records. My lord may records that. My lord may keeps it for hearing. My lord.
No. We are asking you again. We find from the order sheet that there is no extension of interim order beyond 24/3/21.
That is on record. That is on record.
So therefore, there is no question
I
for
will
us
not argue
to.
on that. I will not
So
argue.
there is no question for us to either assume jurisdiction because there is no urgency warranting such assumption of jurisdiction, and there is no occasion for us to pass any order on the tribunal also at the request of such a petitioner who does not take any steps before the tribunal.
But what I have been told, my lord, posts are still vacant.
Anyway.
They have not been filled up yet.
Yes, heard the learned advocate for the
Item number 14.
Anita way number 68.
Hello.
অর্ডারটা তো আমাদের দিয়েছে হয়ে গেছে ওটা এত নিয়ে 25 এটা হচ্ছে পেজ 9 আমার কি বল অর্ডারটা পেজটা বলো তো
Supplementary was to be filed. Already filed. For what?
নয় বাইশ
Because this is an application for
Yes.
Well, the order under appeal is dated
চ্যালেঞ্জ করেনি
July 24, 2025.
intent of the বলছি
Where's the representation of 22/8/24?
চ্যালেঞ্জও করেনি অ্যানেক্টারও করেনি
Eight four. 84.
It's a second August.
Your lordship is asking 22nd August.
Yes.
2nd August.
22nd August 24.
24. One.
Just a minute. Or 14/11/24.
14/11/2024 Millard is in vernacular. And then Millard through proper channel, then Millard 4/3/2025.
4/3/25. What is 4/3/25?
Same representation Millard, carrying repetition. 5 times represent and 22nd August 2024 it has page 103. Your lordship is first.
Is that in vernacular also?
একটা বলেছে স্যার 2022-এর কুড়িটা আগেকার weight সেটা তো করলো করেছে তো এইখানে তো মানে matter হয় না
list
number
56.
আরে আমার ল্যাপটপ পড়ে আছে ইউজ হচ্ছে না, ট্যাব পড়ে আছে ইউজ হচ্ছে, নতুন ট্যাব কিনলাম আবার ইউজ হচ্ছে না, ল্যাপটপটা পড়ে পড়েই নষ্ট হয়ে গেছে। দাঁড়াও যেটা জিজ্ঞেস করি সেটা বল শোনো।
What is your claim?
My claim Millard emanates from that is the appointment data entry, my entry in the service in 2017. 2017 Millard, I have been working. Now Millard 2017 after Millard 3 years Millard we came to know about a memo Millard which is at page 47. This memo Millard ensures certain climate of parity Millard, although not regularization, but it ensures certain security. Now this in the meantime,
Base order is the base notification of 16/11/2009.
no, 20.
Sorry, 19.
I entered 2017.
No, the government decision to give some security of tenure
2020.
is of 2020. Where is that?
16th October 2020.
Where is that?
Page 44. My lord got it. Is it legible?
It's legible. But then there is no such prayer in your representation. In your representation, no such relief has been sought. You are saying certain people name has occurred in the list wherein they have been given this benefit. We have not placed us in that list.
No, I said, Millard, that there was a discontinuation of service we had thrown out. Then we were re-engaged and re-engaged Millard the unskilled labor category.
That's not your case. Your case is that out of 7, 4 persons were given the benefit of the notification. One who was along with them has not been given. Rest of the petitioners have come in later, but they are also entitled. That is your case in so many words.
They sent the list, Millard. The government had sent the list of 121 numbers of the data entry which
Please come to page 105.
105.
Yes, second paragraph.
We inform you that the director such and such was directed to say that the superintendent member secretary of the RKS hospital attached with the newly constructed medical college, namely such and such, was empowered to engage a entry operator, where the payment of salary from risk fund is clearly mentioned. According to that order, the authorities of Malda Medical College Hospital first appointed 7%, later appointed different time 18%, totaling 27% data operators during period 2012 to 2018. In memo number such and such, the government department dated 16 has been benefited 4 numbers out of 7.
So 4 out of the 7 have been given the benefit. Krishna Haldar is the 5th. He is also part of that 7 persons.
Yes.
But he was not. Now come to the next line.
Now Krishna Haldar, son of such and such of the same list.
Same list.
Yes. Who was later appointed in
We all the petitioners who were later appointed. So all of you are, your entry is much later. So how can you claim parity with them?
Question is, my lord, is a question of a preference, my lord, time subject to correction. 16, 10, 20 does not indicate that the persons who were appointed on that particular date under a particular list, only those will be showered with.
No, it does
benefits.
not. But then
No,
if that policy is to be implemented,
the policy is to be implemented, the law is subject to
the
what?
policy requires a particular length of
Uniformity.
qualifying service.
And that I put this question.
So where is your claim? That is what we are trying to see.
Because it is not a new thing. The government has issued.
What is your date of entry? Where we are not able to find that.
The operator at Malda Medical College, my lord, that is in the year 2017.
From where do you get that?
I have pleaded.
Where? Show us. We didn't find in the representation, therefore we are asking.
Yes, my lord, your lordship's query, my lord, I am bound to answer. That, my lord, don't mislead me. If you don't know, then please maintain silence. My lord, first, 2017 is the date that I have said, my lord, the direct engagement under the government of contractual IT regular establishment under such a project, but in case to such and such is a memo. I have referred, page 47. Then, my lord, I have said.
No, where is your date of entry? Please show us.
I'm just. I have categorically stated, my lord. Sorry.
Page number 7.
Page 7, my lord, of your lordship's brief.
6.
Point number 6.
Page 7. No, not from the writ petition. Not from the writ petition.
Not from the OA. From the OA.
From the OA.
Wait a minute.
We are trying to see whether the tribunal has committed an error or not.
Oh, I see.
No,
the way that has been, this is this way. Where is that way? There is a supplementary affidavit. Yeah.
সব declare করেছিল presentation consideration
This way is not a part of the code.
Oh, so
The appointment in the that is not.
all right, no problem. Yes.
And in the earlier.
Yes.
It is in order to follow the 89 lakh.
Why it is not being considered?
Well, may I tell.
They are only seeking consideration. It is your policy.
Yes.
In view of the critical role played by these data entry operators, that is your memorandum notification of 10/10/2020.
My lord, kindly come to, my lord, the copy of the OA application, the first paragraph. OA application, first paragraph. The instant application is directed against the impugned order of rejection made by the Principal Secretary to the Government of West Bengal Department of Health and Family Welfare, whereby the justified claim of the applicant has been ignored while recording the composite rejection order dated 29 September 2022. That rejection order, my lord, has not been challenged in the way. Earlier, an OA application was filed praying for consideration of their representation or petitioner's representation. Now the OA was disposed of, directing the Principal Secretary, my lord, to dispose of the same. Now, my lord, that order, after having been served upon the, my lord, the authority, my lord, passed the order. That is at page number 89 of the writ petition. Considered, rejected. It was not, my lord, challenged before the second OA. And rather the relief sought for was that further consideration of the further representation. And this is the...
So all these writ petitioners were party to the earlier OA?
My lord, so far the present writ petition...
Have you said so? You are parties to the...
Prabhakar Roy was also filed, Prabhakar Roy also filed
Yes,
earlier
sir.
away.
There are two OA applications. The first one,
Single
the earlier
petitioner.
one has not become a part of this record.
No problem. That's not the point. The order in pursuant to that OA is there. So why a successive OA for the same relief?
It appears from page number 89. Earlier OA Prabhakar Roy versus State of
That
West
is
Bengal. OA number
that is
255.
what we are saying.
Yes.
But your lordships are saying, but when the consideration was made by the.
So therefore, if the tribunal was to direct to consider and a rejection order followed, then a third OA would be filed for the same concern.
For the same thing.
So therefore, we are saying why repeatedly? You should have challenged this order if at all you were aggrieved by this order.
The principal secretary, while we are dealing with the issue in terms of the High Court tribunal's order, the principal secretary has taken note. The principal secretary has rejected our claim.
So where is challenge to this rejection? That is precisely what we are asking you. And if not, where is the occasion for the same forum to issue a successive direction every time you approach?
No, that is true, Millard. I have no explanation to offer at this moment. Kindly give me 1 day time so that I can look into the earlier one. I have not seen.
No, it is there. The order is there.
No,
Your
already-
OA, you cannot change your OA. Let us see what you have said in the OA.
No, it is true.
Let us see. Nothing is to be.
Earlier order to the OA order.
Perhaps this is why we would have asked for the OA on the last occasion. We don't know.
No, this question was not asked. Dr. Subhas, this matter was asked.
Well, page 83 of the Malad writ petition, the order passed in earlier OA, Malad, that is Malad annexed here. Page 83, the earlier order passed in case number OA 555. And
Same writ petitioner.
yes, same.
What is this?
It was disposed of, directing the
But
authority
the order
to
that was
consider and
challenged,
dispose of.
that was challenged, Miller, that 16/10/2023, I said that the instant application against the direct, arbitrary and illegal, whimsical, discriminatory action of the respondent not allowing your applicant, IT personnel designated as attendee working under, that is the Miller, the OA number 55/2022.
555.
Cause of action, Miller, kindly cease. This was the affidavit করে দেওয়া আছে. Just now, Miller, I have been served there. I have been handed this. No, the 555.
555.
555, the cause of action 555. That is what I intended to.
That is the order passed in 555 at page 83.
At page 83. But that is for the reason, Miller. Consideration.
Same thing. Again, if we direct, they don't do it, then third, then fourth.
Miller, this was this second writ petition, the second way application, kindly see.
See the relief at page 15. Same relief.
Yes.
Considering the representation.
Miller, says Miller, only directly in the respond to 4 will consider and.
Correct. So same relief.
That was done.
That is already done pursuant to 555.
Now, Miller, this was done.
And that is not challenged.
That was not challenged in the second application. Miller, the principle subject to correction, Miller, if I can show that for the implementation, for the sake of implementation, a second writ petition without filing a complaint, Miller, that is maintainable.
Sorry, we are not inclined.
Miller,
If at all you want to challenge, we leave it open. You can challenge the order of rejection.
but Miller, both this, Miller, this is already been challenged, but the earlier one kindly give me liberty.
That is what we are saying. If at all you challenge the order of the principal secretary.
This one,
Oh no, surely not. Surely not.
Otherwise, Miller, this will stare at our face.
We don't worry. Yes, heard learned advocate for the writ petition.
This is appearing as item number 51 in today's list, Your Lordship. There is a direction by the Honorable Supreme Court yesterday to expeditiously hear out the matter, Your Lordship. I'm praying for taking up the matter anytime today or fix a date at least, Your Lordship.
Why didn't you mention in the morning?
Lordship, the order has not been uploaded yet since it was heard yesterday.
So you mentioned tomorrow we'll fix a date. You come with the order. Yes.
Before taking the next matter, my lord, may I have my lord, that is, my lord, the establishment of Vigilance Commission, that notification, my lord, wanted.
Oh, the manual.
Actually, this is my lord, the notification whereby you are constituted the State Vigilance Commission and my lord, the power, এটা দুটো copy আছে, my lord, দের জন্য। My lord, initially, my lord, 1965, that is my lord, the other option, and then my lord, yes, subsequent functions, my lord, the appointment.
So this is in connection with which matter?
Well, this is in connection with a matter which is, my lord, adjourned and.
Do you remember the case number?
My lord, I should immediately. I should.
Anyway.
It is adjourned to sir. Number 2. But I shall submit the case number.
We will ask the library to bind it so that there is a copy for the court and chamber both. Thank you. Yes.
Matter item number 12.
Yes, Lordship, I am appearing for the Lordship petitioner. Lordship, in this matter, Lordship heard the matter before vacation, and finally, Your Lordship passed an order on 22nd September 25. And Lordship, there was a direction to consider that study leave matter, to rule 175 whether it is public interest or not, and pass a order by 10th of October. And if necessary, I shall move the matter before the Lordship, before the Honorable Vacation Bench. Lordship, they have rejected my prayer on 9th of October 2025. Thereafter, I have Lordship moved the matter before the Honorable Vacation Bench, and with filing a supplementary affidavit annexing the Lordship rejection order. And thereafter, Lordship, the Honorable Lordship Vacation Bench, Lordship passed an order on 14th October 25. Lordship, relevant paragraph is paragraph 3. And the Honorable Vacation Bench, Lordship, observed that yes, upgradation of qualification of a doctor, that is also public interest, and direction given to the authority to Lordship take a appropriate step and found a alternative way how I can be Lordship accommodate the study leave. And thereafter, Lordship, the matter has been sent before the regular bench, and also direction to Lordship expedite the possible to find the disposal. Thereafter, Lordship, last occasion, my learned friend, Lordship, Lordship, there was a direction to file a report, and my learned friend, Lordship, last occasion did not find any report. And today, Lordship, I have been served a report. Just now, I have been served. Lordship, they have again negated my prayer with a view that I have been granted tenure reserve for 3 years in earlier occasion. That is absolutely different thing. I have availed tenure reserve. I have pursued a bond.
You want to proceed?
Yes, Lord.
You want to proceed?
Yes, Lordship.
So there is, you don't want to meet any reply or anything. As you like, we are asking you, we are not saying, we are not suggesting anything. We are asking you whether we should proceed or you want to meet whatever has been stated. Then otherwise the submission is pointless.
Lordship, in that case, Lordship, short accommodation we granted.
So
Lordship,
not today, we'll keep it not today.
because Lordship, I shall file a Lordship
A report.
Huh?
Intercourt appeal hearing, item number 15. Takes a voluntary retirement. For the salary given 2011 31st. As per the direction of the school, he refunded the amount 4,52,970 in Diamond Harbour branch on 6th May 2005. You said still of also sanctioned on 7th June 2011. He held the pension.
The order under appeal. What is the date of the order under appeal? 29. there is any interim order staying the payment. Was there any interim order in this case? First time picking up in. Yes. What do you want? What is your submission? What is wrong with the order? Eleventh. What is the date of his voluntary retirement? VRS. 7 June. From where? Where is that? Fourth page. Six 2011, not 7/6. Hmm? 6/6. Not voluntary. Yeah. Where is the voluntary retirement? He has retired. No, it doesn't look like there is any voluntary retirement. He says his superannuation on 6/6 2011. The order has been complied. No, but there was no stay. Therefore, we are asking you. From 2016, there is no compliance. Eight 40-day delay in filing. We said in the cap. Did I keep that service? Just confused. You have given affidavit of service. You have given only one copy. They kept two copies. Oh. You have not served the CAN application. No, just look what you have said in your serve copy of the memorandum only. You have not served copy of the CAN application. Yes, from the affidavit of service.
If it was served, it could have been dismissed. Retired in 11, died in 13.
Error 16.
When he is not alive.
The appellant, my lord.
Yes.
But I served a copy upon the respondents, but unfortunately, the service status is not available in the server, whether he has received or not. The writ petitioner and the school authority. There is some delay in filing the appeal. This appeal has been filed by the state of West Bengal, my lord.
File an affidavit, whatever it is, on the next day.
Very
No affidavit has been filed regarding.
And I prepared the affidavit, but it is not a form.
Bring it. The application and appeal both.
Yes, my lord, all the application I have served. Memo and appeal, alleging I have connected 2 applications I have served.
Error 17.
None appears for the appellant.
Item 18.
18, I appear for the appellant, my lord. My lord, copy has been misplaced from my custody. It's an old appeal of WBACDCL, lordship. I have desperately searched out my file, my line.
No, but on the last date you wanted to withdraw.
My lord,
On the last day you wanted to withdraw.
WBACDCL, I am mapping for the WBACDCL.
Yes, yes, yes.
My lord, I never paid so, lordship.
Were you appearing earlier in this case?
Yes, my appeal filed by me, Saurabh Chaudhary, I myself.
Please see the last order.
But not withdrawal, my lord.
When you say no, and therefore we ask you whether you have appeared on the earlier date, you are submitting something contrary to the court's order.
Yes, lordship.
So it is very surprising such submission is being made. If you have appeared earlier, you should not say that.
My lord, may I submit, lordship, as it appears from the record, some Mitro appeared. Who submitted so? I did. That is why.
He asked you whether you have appeared, you said yes.
Yes.
What is your name?
Saurabh Chaudhary.
Your name is appearing.
Yes, lordship. I have to go through the entire records and
Why are you pursuing this matter? Have you seen the order? You were directed, there is a direction not to charge a transformer and not to make it operational. Since 2019, it has not been made operational. Only direction was to remove it and make it within 3 feet from the boundary wall. And that is why perhaps you said that you wanted to withdraw. What remains in this?
I want to go through it and I shall take instruction from my client since I'm handicapped for now.
Yes, the last order. Nothing remains that you just have to remove it 3 feet from the boundary as per the statutory requirement. How can you contest that? Yes.
Item 19.
Yes, for the appellant, well, a similar prayer, lordship.
Same.
Yes, lordship. Kindly see.
These orders you have challenged. What will you argue in this case? He has been directed to pay for changing a meter. So what is wrong with the order? Why it should not be done? Tell us.
Well, let me go through the order, then I shall.
Unnecessary burden.
At that point of time, I was instructed, so Lordship, that is why it was filed in the year 2000.
Such litigation at the cost of public exchequer. Just see. You have been directed to forthwith take steps for removal of the defective matter on payment of cost. And you have filed an appeal.
Lordship, I shall come back with proper instruction.
Not today. Next day we will not grant you even 1 minute's time. Item 20. None appears for the appellant. For lawyer. Item 21. None appears for either of the. We have seen time was granted by the Lavazima, still no application.
122.
None appears for either.
And 23.
খাওয়া দাওয়া আছে তার জন্য বন্ধ বার কাউন্সিল
Came out.
And 24.
Lord, in item number 24, my lord, I beg to appear on behalf of the petitioner, appellant petitioner. Lord, this is affidavit of service, my lord.
Right. A copy of the state petition, not a copy of the section 5 application for Starbucks.
My lord, it has been served through affidavit. Affidavit has stated, I'll provide my learned friend if it has not been received, but that was, the affidavit of service will speak that we have sent everything.
So you are the only respondent,
I'm only the further respondent.
sole respondent.
স্যার আমি পাঠিয়েছি, আপনি না পেলে আমি দিয়ে দেবো। ঠিক আছে, আমি দিয়ে দেবো। আমি দিয়ে দেবো, আমি পাঠিয়েছি আপনার ক্লায়েন্টকে, দেখুন পুরোটা পাঠিয়েছি। স্যার আপনি থাকবেন এখানে, আমি কি করে, আপনি লোয়ার কোর্টে ছিলেন, তা আপনি এখানেই থাকবেন আমি My lord, there is one section 5 also.
How many days delay?
90 days of delay.
90.
90 days.
So what is the ground for a sailing?
Ground is that, my lord, under Rule 99(2) of the Railway Protection Force Act, my lord, the promotion is to be given, my lord, after a person completes 7 years of service.
As sub-inspector. Sub-inspector.
Yes, my lord. Now, there was a subsequent notification, my lord, by the Railway Board, my lord, which speaks of that if anybody on his own wish want a transfer and transfer happens, that 7 years has to be completed on the place where he has transferred. If it is on his own volition transfer. So that
So
was
it is not only a period, it is also the place where he works, the period has to qualify.
period also, my lord, here in the new place of posting, if it is an own volition transfer, if he wants
That we have understood. So what you are saying is, if under those circumstances he is transferred, irrespective of the fact that he may have worked 6.5 years, he will require to work another 7 years at the transfer,
that is the note.
at the transferred place of posting. This is substance what you are submitting.
Substance.
So where is that notification which mandates?
Notification is, my lord, at, my lord, this with the stay petition, my lord.
I have worked for 6.5 years. I have
There is. Let's see.
My lord, it is there at, my lord.
That is the only issue.
That is the only issue, my lord.
Just let us see the notification.
My lord, my lord.
Please, we'll call on. Please sit down.
Dear my lord.
That will be profited. Oh, that is. Oh. That. Give length of sun. His posting is 10. He will lose his seniority.
My lord, this is at, my lord, if your lordship kindly takes up.
Because they are about seniority is the issue. But if seniority is not issue, it is length of service. Then only correct.
My lord, that is if your lordship kindly takes up the stay application, that is annexed there, my lord.
Can too.
Can, my lord, this one is can, most probably can.
Yes, we have got it. Which page? We have got it. Which page?
My lord, page 79. They have now all been after completion, got their promotion as an inspector, but the issue remains, my lord. 79, my lord, cross code. Cross code, my lord, have your lordship find out.
They are enrolled members,
They are enrolled members, my lord.
sub-inspector.
Enrolled members and enrolled member of the force. That is there, my lord. We'll find out, my lord, from the provisions and from the, my lord, this is the enrolled members. Enrolled
See,
member.
because it appears that in clause 3, there is a specific provision for promotion from sub-inspector to inspector.
My lord.
Clause 4 deals with enrolled members, and clause 5 deals with ministerial and executive staff. So whether they are enrolled members?
Yes, my lord, if your lordship, my lord, have a look at section 2BA, my lord. They are enrolled member of the force.
And this notification was not challenged by them.
That notification was not challenged. That was
In
not
the writ
challenged.
proceeding.
No, my lord. They are challenged that they have not been promoted, and this is
That we have understood. So this they did not challenge.
notice they did not challenge. But here that has come. My lord, 2A, my lord, I'm giving, my lord. 2BA, my lord. Enrolled member, all subordinate.
How can it be? BAC, it says enrolled member means below the rank of under officer.
Yes, my lord. That is there in the annexure, my lord. The schedule 2 speaks of the superior officer, my lord. Who are the superior officers? And
We asked you whether he is enrolled member.
my lord, they are enrolled member. My lord, if your lordship,
Enrolled member is defined in 2BA.
2BA.
2BA says enrolled member means any subordinate officer, under officer, or any other member of the force of a rank lower than that of under officer. So sub-inspector is below an under officer.
My lord, if
Cannot be. Under officer is a head constable and Nayak. How a sub-inspector can be below a head constable and Nayak?
speaks of, my lord, enrollment is subordinate under the under officer. Or
Now under
near
officer is defined in FA of 2 itself.
FA.
2FA. That's head constable. That is below sub-inspector.
My lord,
They are not enrolled members.
Means a subordinate officer or means any subordinate officer, under officer, or any other officer of the force of rank lower than that of under.
Lower rank than under officer.
My lord, not only means any subordinate officer also.
All lower than under officer.
My lord, if I may place, my lord,
You
enrolled
please
member.
read it again.
My
Yes.
lord, means any subordinate.
Any subordinate officer, under officer, or any.
Or my lord, or any member of the
Yes.
force of the rank lower than that of under officer. That means, my lord, subordinate officer, under officer,
All
or
of
any
them.
other
All are enrolled.
Huh?
All are considered.
All are enrolled. And my lord, if your lordship kindly takes to this, which provides, my lord, subordinate officers, which include, my lord, that is, my lord, is schedule 2, my lord. If your lordship kindly takes up schedule 2 at page 122, my lord. From the rank of inspector, they are subordinate officers. At page 122. Have your lordship find out anything?
Give him a copy. He says he has not got a copy of the application. You give him a copy.
Well, I'll provide.
Let
Sir, আপনার page. আপনাকে স্যার Mr. Mojumdar is very easily to be found. He is one of the most senior most.
25.
let us see. By way of last indulgence, we are
And 26.
Correct, correct.
What to do with the report?
Apart from that, he has said that nobody but the electing the party shall see the and it cannot be dealt with other officers. Whether to return it, pending the single judge still on. It's information they can. There is stay in the proceeding.
Yes, there is none to represent.
And 27.
Yes, same order.
Twenty-eight. Hmm. Hmm. Same order. Twenty-nine.
Same order.
Item 30.
In this matter,
I am appearing for the respondent.
Lordship, in this matter, KBS Mohapatra is appearing for the petitioner. Lordship, our brief is misplaced. Lordship, kindly adjourn this matter for 1 week at least.
Notice.
Supplementary epithet regarding the repetition. তো চোখ করতে প্রত্যেক সিস্টেম যে রিপিটিশনটা লাগানো নেই তখন করেছে
Yes, what are you submitting?
last occasion matter was that you have before the honorable justice of the same. There is the direction to annex the repetition.
What is the date of that order?
That was on 30th January 2025. Not annexed. With that,
Stay application. You are appearing in 30, serial 30. Yes. Which can?
an appeal for appropriate order for expeditious here. But I
But there is no order for filing any writ petition. We don't find there is any order here.
take my method. Get that without which I don't
As prayed by the learned advocate.
Item 31.
cannot. There is forbidden balance in the what is an inappropriate order? Inappropriate order.
None appears for either party. None appears for either.
For your lordship rises. There were 9 matters which was released by Honorable Justice Rajshri Bharadwaj yesterday. We mentioned those matters today before the Honorable Chief Justice, my lord. Those matters have been assigned to your lordship, my lord.
We don't know.
No, my lord, that has been informed to your court officers, my lord. Why I'm here before your lordship is the interim order is expiring on 28th. This urgency was informed. Now, these are the 9 matters. If it could come,
Sir, we don't know unless we see the assignment. How can we do it?
my lord, the
If there is an assignment, we'll see. Don't worry.
shall I hand over the mentioning slip?
You can give it, but unless the assignment is there, we will not do anything.
My
Yes.
only difficult.